Mr. President,
To the Senator from Kentucky.
Article 2, Section 4 of the Constitution says, "The President, Vice President, and all civil officers of the United States shall be removed from office on impeachment for and conviction of treason, bribery, or other high crimes and misdemeanors." Article 1, Section 3, Clause 6 states, "When the President of the United States is tried, the Chief Justice shall preside." As of noon last Wednesday, Donald Trump holds none of the positions listed in the Constitution. He is a private citizen. The presiding officer is not the Chief Justice, nor does he claim to be. His presence and the Chief Justice's absence demonstrate that this is not a trial of the President, but of a private citizen. Therefore, I make a point of order that this proceeding, which would try a private citizen and not a president, a vice president, or civil officer, violates the Constitution and is not in order.
Under the precedents of the Senate regarding constitutional points of order, including those of the Senate while sitting as a court of impeachment, the chair submits the question to the Senate. Is the point of order well taken?
Mr. President,
The Majority Leader.
the theory that the impeachment of a former official is unconstitutional is flat out wrong by every frame of analysis: constitutional context, historical practice, precedent, and basic common sense. It's been completely debunked by constitutional scholars from all across the political spectrum. Now, the junior senator from Kentucky read one clause from the Constitution about the Senate's impeachment powers. He left out another from Article 3, Section 2, quote, "Judgment in cases of impeachment shall not extend further than to removal from office and disqualification to hold and enjoy any office of honor, trust, or profit under the United States," unquote. If the framers intended impeachment to merely be a vehicle to remove sitting officials from their office, they would not have included that additional provision, disqualification from future office. The Constitution also gives the Senate, quote, "the sole power to try all impeachments." So what have past Senates decided on this question? In 1876, President Grant's Secretary of War, William Belknap, literally raced to the White House to tender his resignation before the House was set to vote on his impeachment. Not only did the House move forward with the impeachment, but the Senate convened a trial and voted as a chamber that Mr. Belknap could be tried, quote, "for acts done as Secretary of War, notwithstanding his resignation of said office." The language is crystal clear, without any ambiguity. The history and precedent is clear. The Senate has the power to try former officials, and the reasons for that are basic common sense. It makes no sense whatsoever that a president or any official could commit a heinous crime against our country and then defeat Congress's impeachment powers and avoid a vote on disqualification by simply resigning, or by waiting to commit that offense until their last few weeks in office. The theory that the Senate can't try former officials would amount to a constitutional get-out-of-jail-free card for any president who commits an impeachable offense. Ironically, the senator from Kentucky's motion would do an injury to the Constitution by rendering the disqualification clause effectively moot. So again, by constitutional text, precedent, and common basic sense, it is clearly and certainly constitutional to hold a trial for a former official. Former President Trump committed, in the view of many, including myself, the gravest offense ever committed by a president of the United States. The Senate will